नमस्कार। इंसॉल्वेंसी वेटरन्स में आपका हार्दिक स्वागत, अभिनंदन। Today we would be discussing an interesting case where Court 2 of the Mumbai Bench of NCLT has passed an interesting order wherein on the application filed by the liquidator of Petron Engineering Construction Limited, the bench has ordered NTPC. NTPC is in this case a debtor of the corporate debtor. The bench has ordered NTPC to make the payment of rupees 12.36 crore to the liquidator of the corporate debtor, Petron Engineering Construction Limited. It is slightly departing from the established jurisprudence in this regard. The bench, while ordering NTPC to make the payment of rupees 12.36 crore to NTPC, directed NTPC to make the payment to the corporate debtor, stating that the Honorable Supreme Court in Gujarat, Urja, Vikas Nigam Limited case had made an observation that for any matter relating to the insolvency of the corporate debtor, the NCLT is the authority to decide on the disputes or about the insolvency of the corporate debtor. Whereas in NCLAT, in its order in the case of Ramachandra D Choudhary versus Bansal Trading Company, it has clearly mentioned by NCLAT, which I'll read for you. It says that keeping in view of the judgment of Gujarat Urja Vikas Nigam Limited, the remedy of debts disputed or not. We have to underline this particular phrase, recovery of dues disputed or not, cannot be determined in summary proceedings, and the code does not contemplate adjudication of any such nature. Any such steps taken under section 60 subsection 5 of the code before the adjudicating authority would tantamount to bypassing or short-circuiting the judicial proceedings. This is the order specifically on this issue by NCLAT. As a matter of fact, being on the bench and otherwise also, I have been following the same thing. Till now, the jurisprudence developed with respect to the intervention of NCLT on the issue of recovery from debtors of the corporate debtor is that NCLT cannot adjudicate such disputes in summary proceedings, and the IRP, RP or the liquidator, as the case may be, need to take steps for recovery of the dues in the appropriate courts. Now, with this order, we are venturing into another regime where in almost all the cases where we have one corporate debtor, we may be having hundreds or thousands of the debtors of the corporate debtor, and the IRP, RP or liquidator would be coming to the bench stating that please assist me in getting the money recovered from the debtors of the corporate debtor, which itself is not the mandate with NCLT. To the best of my mind, NCLT should not get into the adventure of directing the debtors of the corporate debtor to pay or not to pay the dues in summary proceedings like this except in PUFE. PUFE means preferential, undervalued, fraudulent or extraordinary transactions which are clearly mandated within the code that those are to be dealt by NCLT, and that too on the application of filed by the IRP, RP or the liquidator. These are my views, and not necessarily that all the benches are following the same, but this is the position of law as on date, and NCLT should not be adventuring into directing the recovery of amounts from the debtor of the corporate debtor, even on the application filed by the IRP, RP or the liquidator, except in PUFE transactions. Thank you. The relevant case laws are given in the caption. Thank you very much.